Welcome to the debate. We are diving immediately into the profound constitutional conflict that's emerging from Minneapolis. It's all following the fatal shooting of a U.S. citizen, Renee Good, by an ICE agent, Jonathan Ross, during this massive Operation Metro surge. The central question here is, well, it's seismic. It moves far beyond just criminal liability and into the very structure of federalism itself. When a federal agent uses lethal force inside a non cooperative state jurisdiction, what constitutional standard of immunity applies? And must federal operational methods be subject to state criminal law and evidence based scrutiny? I'm going to argue for a broad, almost mandatory supremacy clause immunity, which is absolutely necessary to ensure the viability of federal law enforcement across the country.
And I come at it from a different angle. While, of course, we all respect the necessity of federal enforcement, we have to uphold a much narrower interpretation of that immunity. It's rooted fundamentally in dual sovereignty and the state's reserved police power. The state must retain the functional ability to hold federal agents accountable when their actions are objectively unreasonable or just plain unauthorized by law. I mean, what we seem to be seeing from the video evidence and the immediate jurisdictional breakdown in Minneapolis is a state fulfilling its necessary role as a constitutional check on potential federal overreach.
Well, my position is founded on a structural necessity, a concept that's, deeply entrenched in case law going back over a century. Specifically, the principles from Tennessee v. Davis and in Renee. States simply cannot be allowed to use local criminal law, like the threat of murder or manslaughter charges, as some kind of political tool to obstruct lawful federal duties. The Supreme Court established this back in the 1890s in the Nicole case, where they protected a U.S. Marshal who shot and killed an assailant of a Supreme Court justice, no less. The court ruled that the Marshal was acting pursuant to a necessary and proper federal duty, even if no explicit statute authorized that specific action. So the standard for immunity, it has to be highly differential. It has to focus on whether the officer, quote, reasonably believed his actions were necessary and proper in discharging his duties, to, quote, weaponize her vehicle. And we know the agent had prior experience being dragged by a vehicle during an arrest. That gives critical, immediate context to his fear and his instantaneous judgment in that highly exigent moment. I mean, look, if officials like Mayor Frey and AG Ellison can dictate when and how a sanctioned federal operation occurs just by threatening local prosecution, the essential function of the federal government is paralyzed. We have to protect the agent's ability to act decisively in the field under a perceived threat.
See, that reliance on a subjective, reasonable belief is exactly where the constitutional balance breaks down, especially in a lethal force situation involving an unarmed civilian. I'll grant you the historical context of preventing outright state nullification of federal law. That is a legitimate concern. But we have to adhere to the precise language of the Constitution itself. Supremacy is granted only to laws made in pursuance thereof. And that phrase is crucial. It means federal power is inherently limited by its enumerated powers, reserving essential state police powers, including the authority to criminalize acts of violence like murder or manslaughter, to the states. That was affirmed powerfully in Prince versus United States. This is a case of potential criminal acts by an agent operating outside of objective reasonableness. Renee Good was a U.S. citizen.
She was a legal observer who, according to witness videos that Mayor Frey cited, was backing up and trying to get out of the situation. So, state criminal prosecution here isn't obstruction. It's a critical instrument of constitutional redress against documented federal overreach in our system of dual sovereignty. And the federal government's actions have only compounded the problem. When the FBI immediately refused the Minnesota Bureau of Criminal Apprehension, the BCA, access to scene evidence, that was an explicit attempt to avoid the accountability function of the state. The immunity standard must be objectively rigorous. It has to ask whether the agent's actions were manifestly or palpably beyond his authority, which, the visual evidence seems to suggest.
Okay, let's focus specifically on that standard of reasonableness in these high-stakes lethal force situations. The operational context of Operation Metro Surge, a major multi-jurisdictional tactical enforcement action, it demands deference to the agent's instantaneous split-second judgment in a volatile environment.
We are talking about ERO SRT agents. These people are trained for kinetic situations, not, beat cops responding to a noise complaint. And we have legal precedent that shields the agent. I mean, think about the Bijan Geyser case. There, park police officers shot and killed an unarmed motorist. State prosecutors charged them with manslaughter, fulfilling exactly the role you describe, the state checking federal power.
Sure.
Yet the case was immediately removed to federal court under 28 U.S.C. 1442, which allows federal officers who are charged for actions taken under color of office to move their defense out of what could be hostile state courts. And crucially, a federal judge ultimately dismissed those criminal charges, explicitly ruling that the officer's decision to shoot was, quote, necessary and proper under the circumstances. This dismissal, following removal, it demonstrates the legal shield in action. Under the narrowest reading of In re Nigel, if the agent reasonably believed he was fearing for his life after being charged by the vehicle, which is what the federal narrative asserts, that is sufficient for immunity. The Supremacy Clause ensures that a potentially hostile local jury can't retroactively criminalize a federal agent's necessary self-defense. The chilling effect on federal law enforcement if this protection is removed would be disastrous.
I see why you rely so heavily on the Geyser outcome, but the removal statute you're citing, 28 U.S.C. Section 1442, it's not an automatic grant of immunity. It's a change of venue. And even that removal doesn't negate the state's initial constitutional function. The viability of state criminal oversight is actually proven by the mere fact that the state was able to bring charges in the first place, forcing the federal government to actively defend the officer's actions in a court of law. More fundamentally, the objective evidence of Minneapolis has to challenge the federal narrative. We need to move beyond subjective fear. The DHS's own use of force policy states that deadly force cannot be used solely to stop someone who is fleeing. So if witness videos and BCA analysis confirm Renee Good was attempting to flee or back away, then the agent's action was likely outside the scope of acceptable federal conduct.
And once that act is deemed unlawful under their own policy, the agent is, by definition, operating outside the scope of his employment. And if that happens, the protection afforded by Nigel, it just disappears. Immunity isn't a license for criminal behavior. It's a shield for lawful, necessary action. And this brings us to a fundamentally modern challenge to your structural argument. We've been discussing historical case law and the officer's momentary judgment, but the state is essentially trying to change the playing field entirely. They're introducing a new legal tactic, moving from looking at intent to looking at measurable statistical impact. Minnesota's AG, Keith Ellison, is commissioning or utilizing empirical data, stuff often associated with frameworks developed by, actuarial professionals and risk management groups like the Access to Justice Lab.
The data apparently argues that the federal surge created a statistically significant increase in violence against citizens without actually improving public safety metrics. This is a profound legal maneuver. The state is arguing that if the method itself, the Metro Surge operation, is demonstrably arbitrary and capriciously executed, it bolsters the argument that the federal government is acting outside the legal boundaries required for Supremacy Clause protection, thereby forfeiting operational immunity. It's an evidence-based approach that seeks to prove that the federal action wasn't genuinely in pursuance of law, but was instead a reckless endeavor that failed even on its own terms.
I'm not convinced by that line of reasoning because it attempts to fundamentally confuse operational efficiency with constitutional rights. Legal immunity is a structural constitutional doctrine. It was established to protect the federal government's core function. It is not, and it cannot be, a question of optimal risk management evaluated by academics or statisticians. I understand that the state is attempting to frame this using actuarial risk assessment tools, maybe even referencing something like the ISO 3100 framework, which is usually applied to corporate governance or financial hazard analysis. They're trying to identify the reputational risk and the operational risk of this metro surge. But a statistical risk analysis simply cannot override the necessity for an individual agent to act instantaneously in self-defense. Are you suggesting that if a state commission study finds a federal operation is statistically poor, that finding retroactively invalidates the Fourth Amendment standard, the standard of an officer's action in that moment? The answer has to be no.
This maneuver by the state, creating the public evidence portal and commissioning these studies, it's merely a strategic tactic. It's a risk treatment strategy designed to turn a criminal liability case into a political and policy battle, distracting from the federal mission of enforcing immigration law. We can't allow external actuarial standards to become some kind of condition for constitutional immunity. And this confrontation brings us to the third core point, the jurisdictional warfare that's currently being waged. This level of state defiance, it actually justifies the aggressive federal posture. Mayor Frey explicitly told ICE to get the F-bomb out of Minneapolis. Governor Walz put the National Guard on notice, potentially to counter federal law enforcement actions.
Such actions are a direct assault on federal authority.
This defiance is exactly why federal warnings of retaliation, like the threat by former AG Pam Bondi to prosecute state officials who cross that red line for obstruction or even seditious conspiracy, are necessary. These threats, they exist to preserve the viability of federal action against hostile sanctuary jurisdictions. If cities like Chicago and Denver successfully implement ICE-free zones or ban the use of city property for staging operations or deny airport access for deportation flights, well, the entire federal enforcement structure collapses. Supremacy must be robust enough to prevent the wholesale subversion of federal law by local political resistance. We are talking about the entire federal system.
We agree that the stakes are incredibly high, but let me bring the focus back to the foundational structure of the 10th Amendment. Your argument for robust supremacy, it glosses over the anti-commandeering principle that was established in Prince versus United States. That ruling forbids the federal government from coercing state and local officials to execute federal law. The actions taken by Minneapolis, the Minnesota Attorney General's demand for an independent state review, Chicago's use of property bans, that's not seditious conspiracy. Those are legitimate 10th Amendment defenses. These jurisdictions are ensuring that local police powers are reserved to the states and are not co-opted or superseded by federal operations that they perceive as abusive or illegal. If the federal government needs to enforce its laws, it has to use its own resources. It can't attempt to bend state officials to its will or operate without basic local accountability. The history of federal immunity cases confirms this vital check and balance function. Immunity cases, they cluster during periods of high friction. The enforcement of prohibition, the Reconstruction period, the Civil Rights era. And each time, the debate focuses on where federal power exceeds its lawful mandate and infringes upon local sovereignty. The state's role as a check on federal abuse is historically validated. It's not an aberration. This is the system working exactly as the framers intended when facing potential government overreach.
That analysis, however, overlooks the practical distinction between refusing to cooperate and actively obstructing. When a governor mobilizes the National Guard in anticipation of interfering with a legitimate federal operation, or when city officials issue explicit bans designed purely to derail enforcement, that crosses the line from 10th Amendment protection into direct, unwarranted state interference with the execution of federal law. If the federal operation is found to be in pursuance of law, then the state's opposition is, by definition, unconstitutional obstruction under the Supremacy Clause. The risks of state-level criminal liability leading to the complete chilling of agents making split-second decisions, that has to outweigh the state's desire to micromanage federal operations based on local political opposition or the statistical risk reports.
But the federal action is only in pursuance of law if the individual agent's conduct meets an objective standard of reasonableness and if the overall operation isn't arbitrary and capricious, as the state's data suggests it might be. When you combine video evidence showing Renee Good attempting to flee with data suggesting the operation created more violence than safety, the shield of immunity becomes dangerously thin. We have to empower the state to test the legality of that conduct. The state isn't seeking to halt all federal operations. It is seeking accountability for one specific lethal act that occurred on its soil against its citizen.
To summarize my position, while the death of Renee Good is tragic and deeply regrettable, we cannot allow this incident to erode the foundational principle of federal supremacy. It's necessary for the efficient execution of nationwide law enforcement operations. The risks of chilling federal agents through local criminal liability for split-second decisions made in high-threat environments are just too high for our constitutional structure to bear. We have to defer to the agent's judgment under the protective scope of in re nihil to ensure the federal government can remain a functional entity.
Ultimately, the constitutional balance in this country demands that federal officers who operate on state streets remain accountable to state criminal law, especially when their actions appear objectively unreasonable, as is so strongly suggested by the video evidence. Furthermore, the modern application of sophisticated empirical risk analyses, as commissioned by the state, it helps to prove that the federal action was potentially outside the bounds of lawful necessity. Immunity should never, ever serve as an absolute shield against egregious, locally proven misconduct.
Ultimately, the tension between supremacy and dual sovereignty remains profound.
It does. And the ultimate resolution of this constitutional standoff, whether it happens through federal court adjudication or political confrontation over a potential state arrest warrant for this federal officer, it will fundamentally redefine the limits of federal power and local sovereignty in this age of data-driven enforcement. There is clearly much more to explore here.